Assalamualaikum and hi, my name is Farah Nazira binti Muhammad Noor and my metric number is 252827, and for assignment 2, I choose the article Equity in Trust Law Applications in Malaysia, UK and US in tandem or apart by Guru Dilon, Dr. Nur Muhammad and Ng Yip Min. The first principle that I have learned in the article is duties of trustee. In United States, duties of trustees are governed by Title 11, Chapter 7, and Subchapter 1, Section 704 of the United States Code. A trustee shall be accountable for all property received, furnish such information concerning their estate and the estate administration as is requested by a party in interest, and make a final report and file a final account of the administration of the estate with the court and with the United States trustee. In United Kingdom, a trustee is under a fiduciary duty. One of it is purchasing of the trust estate. When a trustee purchases trust property, the beneficiary can set aside the sale as stated in the case of Wright against Morgan. Next, a trustee is under the duty not to compete against the trust as stated in the case of Free Thompson. Also, a trustee is under a duty of care and a trustee is under a duty not to claim for remuneration as stated in the case of Credit against Piper. While in Malaysia, duties of trustees can be seen in Section 9 of the Trustees Incorporation Act 1952, whereby all powers conferred on the trustee shall be carried out according to his discretion but are subject to consent or direction. Section 15 states that the trustee is to keep accounts and to render a no returns of accounts. Next, the trustee must administer and distribute the trust estate according to the provisions of the trust. A trustee also has to pay all the trust expenses required by the trust document. The trustee has the duty to keep record of all receipts, expenditures, and any other important documents relating to the trust, and these documents should be easily accessible to the beneficiaries. There are also similarities between these three countries in relation to the duties of the trustee. The first one is duty of loyalty, duty to collect and protect trust assets, duty to identify assets as trust property, duty not to commingle trust fund, and duty not to delegate. Next, the second principle that I have found in the article is powers of trustee. In United Kingdom, a trustee may appoint a broker or solicitor to do the ordinary business. A trustee is not liable if broker or solicitor turns out to be dishonest. However, prior to Trustee Act 2000, trustee was liable for misconduct of an agent only if the trustee had been guilty of willful default. While in United States, trustees may hand over administrative responsibilities, but they are not allowed to delegate their discretionary duties. In Uniform Trust Code provides that a trustee may delegate duties and powers that a prudent trustee of comparable skills could properly delegate under the circumstances. The third principle is the breach of trust. The definition of breach of trust is an action of a trustee which results in a contravening of his or her duties. According to the American Uniform Trust Code, Section 1001 provides that a violation by a trustee of a duty the trustee owes to a beneficiary is a breach of trust. A breach of trust may occur by reason of an action or by reason of a failure to act. However, there is no difference in the meaning of breach of trust between Malaysia, UK, and the US. Defenses for breach of trust. In United Kingdom and Malaysia, a trustee may rely on exclusion clauses to validly exclude liability should there be any act on the part of the trustees that amounts to a breach of trust. This can be seen in the case of Armitage against Nurse, where a trustee will not be liable for any damage or loss which happens to the fund. In the United States, Section 1008 of Uniform Trust Code 2000 provides that a term of a trust relieving a trustee of liability for breach of trust is unenforceable to the extent that it, first, relieve the trustee of liability for breach of trust committed in bad faith or with reckless indifference to the purposes of the trust or the interests of the beneficiary, or second, was instituted as the result of an abuse by the trustee of a fiduciary or confidential relationship to the settler. By comparing UK and US trust law, we can see that the US trust law has more restrictive effect of exclusion clause. The fourth principle can be seen from the form of trust, especially under the secret trust. In the United States, there is no secret trust, but only living trust and conventional revocable trust. For probate posting to be eliminated after the settler passes away, and for the service of out-of-court management of the assets when the settler is under incapacity. for tax application to obtain a maximum benefit, settlor would want the trust to be subject to grantor rules. In United Kingdom, there is only secret trust to fully secret or half secret trust. Living trust is not a norm in UK because concept of irrevocability is vital as much as the existing majority of trusts which has been established within the US which are revocable. Once settlor retains any benefit from the trust assets, the least favorable tax consequences would result. While in Malaysia, there are secret trusts and charitable trusts. Charitable trust has been influenced by English case law and the Charitable Uses Act 1601. Since Malaysia is a multiracial country, charities, charitable institutions, and trustees are governed by Section 15C, Schedule 9, List 1 of the Federal List, excluding Wakaf and Hindu endowments. Hindu endowments are covered by Section 9, 1 to 15C, whereas Wakaf are dealt with under List 2 of the State List.